All right, thanks everybody who's here. I hope you guys can all see my screen. Um, I am not looking at the chat. So if you guys have questions, please just unmute and ask away, because I won't see it in the chat box. I also don't see any faces, so if you're doing the little hand raise emoji thing, I'm not seeing that either. So today's class, real estate, what should I know? This is kind of your intro into how to run your business, how we do our business here at Keller Williams. First thing I want to talk about is advertising. So hopefully we all know there's rules about advertising. We have to advertise our brokerage name. Anybody know what our brokerage name is? If you want to unmute, we got choices here. It's Keller Williams. Is it Living or is it Keller Williams Living? If you guys want to unmute and take a stab at this, please feel free.
Isn't it Living?
It is Living. Good job, Danny. Thank you. Yeah. So as far as the state is concerned, our brokerage name is Living. It's not Keller Williams. Keller Williams is a franchise name, and it's not Keller Williams Living. It's just Living. If you look up our registered name with the state, it's Solon Real Estate LLC, DBA Living. So when you're advertising, the living is the part that needs to be advertised everywhere. When we talk about advertising, that's a pretty broad term, I guess. It can be what you plaster on the side of your car. It could be if you're doing billboards, if you're doing your business cards, if you've got clothing branded to you, any of that stuff, any of these kind of like water bottle giveaways, that's all advertising. So knowing that our brokerage name is Living, and knowing that we are Keller Williams franchise, so we also have the Keller Williams rules to advertise Keller Williams. And knowing the Living needs to be more predominant than the licensee's name, than our name. There's several choices up here of how I could advertise my name. 3 of these 4 are wrong. Anybody want to take a guess at which one's correct and which 3 are wrong?
Is the bottom left one correct and then the other 3 are wrong?
Correct, yes. So what, Danny, why did you pick that one?
Because your name is not as prominent as Living.
Correct, yes. So Living it needs to be more predominant than Rick Tannenbaum. Here, the first one is wrong because, well, there's a couple reasons this one's wrong. We're not Keller Williams Living Realty. And also my name and Keller Williams Living is of equal predominance. This one here on the top right is incorrect because Living is clearly less predominant than my name. The bottom right is not correct because it doesn't even say Living anywhere, just says Keller Williams, which is not correct. And then the bottom left was the correct answer. My name is smaller than Living. The state's going to ignore this part here that says Keller Williams. They're only looking at the brokerage name, which as far as the state's concerned is Living, is more predominant than my name. So yeah. Advertising a listing. So a couple questions as we advertise listings. Is the listing your listing? Does it belong to Keller Williams Living? Do you have the other broker's permission to advertise it? And do you have the Keller Williams Living listing agent's permission to advertise it? So I don't see faces who's on the Zoom, but I know Danny is on here, so I'm going to pick on Danny for a second. Danny, Danny has a listing. I want to advertise it. shouldn't be a problem, but what step do I have to take before I advertise Danny's listing? Anybody? It's the answer's right on your screen. I have to ask permission from Danny, who's the listing agent. Hey, Danny, do I have permission? Can I advertise your listing on Main Street? I want to put a social media post. Danny says yes. Great, I can go advertise it. Um, so obviously, if it's my own listing, I have permission from the seller in my listing agreement. That's no issue. Um, if it belongs to Keller Williams Living, we just need to ask that agent permission. It's always best, even though it's within the office, it's always best to have it in writing. So I would send Danny an email or a text message and say, "Hey, Danny, can I advertise your listing on Main Street?" And he replies, "Yes," then I'm good to go. You should, if you're ever asked that by another agent, you should be making sure it's okay with your client as well. And you may want to know what kind of advertising they're doing with your listing, because you want to make sure that that agent who's advertising it is also putting it in the right light that you and your client would like it to show that particular way. If the listing is with another brokerage, you can still advertise it. Now you need the broker's permission. So you should be emailing. I would start with that agent, but really the listing belongs to the broker. So you should really be asking permission from the broker. But at least at a very minimum, get that listing agent's written permission that yes, you can advertise my listing on Main Street. Make sense? Okay. Anytime we do any mailings, the only address we're allowed to use is our business address. It doesn't matter if you work from home, you don't come into the office. You can never use your home address or a PO box or any other address on any return labels except for, or any advertising for that matter, whether it's a mailing or it's advertising, you're always advertising our Solon Road address as our address of business. That's a license requirement, that whenever you have an address, it has to be the office address. It was just asked of me, this might be on a future slide too, but it was just asked by an agent in our office if they have to advertise the address on Solon Road. The answer is no. If you don't want the address on Solon Road on your business card, you don't have to put it on your business card or any advertising. But if you put an address, it has to be the Solon address. Social media rules. There's something called the one-click rule. So whenever we're on social media, first of all, if you're advertising, if you're doing any advertising on Facebook, we obviously do a lot of that as agents, whether it's Facebook or Instagram, or any other social media. Make sure that you're still following that rule about the listing brokerage has to be there. Now there is a rule on social media. It's called the one-click rule. Within one click of the original post, the consumer needs to know that you're with Keller Williams Living. So within one click, they have to be able to tell that you're a licensed real estate agent. But anywhere you put your name on it, remember, it has to have living as well. So that's the one click rule with social media. Any questions about advertising before I get into MLS?
Yes, quick question, Rick.
Yeah.
So the one click rule, does that mean like say I'm on Instagram and like I'm not sure if you're too familiar with Instagram, but you could post like multiple pictures and like you like swipe to the left or right. Um, would that be considered as the one click rule too? Like if your branding or whatever is not on the very first picture, it would have to be on the second.
Yeah, but I would recommend that it's just, I mean, the easiest way to stay out of trouble, I would recommend with Instagram where you have multiple photos, is just put a watermark in the corner that has Keller Williams Living. And
Okay,
then if it has
gotcha.
your name on it, then it's there too. But I think that would be my advice. And I'm saying this, I'm I'm too old for Instagram, just being honest.
Yeah.
I try to
No, you're
use
good.
it, but I try to use it, but I don't really know what I'm doing with Instagram. So my advice, with the little bit I do know about it, is just brand it. I think
All right.
that's the best. You can also on Instagram you can put comments, right? There or remarks, right? There's like a
Yeah. Yeah.
you can always put it in there too, and then there's no question if somebody ever happens to turn you in and say, "Hey, there's a picture of a house for sale and it's got your name on it," and it's clearly an advertisement, and you didn't advertise Keller Williams living anywhere on that post. Well, I think there would be a good argument to say that if you read the post, the the actual text of the
Yeah.
post,
Gotcha.
it's in there.
All right. Thank you.
Hmm. Anybody else before I move on? Okay. MLS rules. Um, we all know that we're all responsible for our own listing entry here, unless you're on a team that has an admin that helps you with it. But in general, our agents are doing their own MLS entry. So when you have a new listing, you're going to be responsible for entering it in. You're going to be responsible for status changes if it goes to pending or contingent, under contract, no showings, or under contract showings allowed. You'll be responsible for making any of those changes and making sure that you follow the rules of the MLS about changing that status. Um, hopefully we all know about the 48-hour rule, which means that within 48 hours, that status needs to be updated in the MLS. So if you listed something today, obviously my recommendation would be to get it in the MLS today if you have a new listing today. But at the very least, you have to have it in. Let's see, today is Thursday. No, what day is today? Thursday. So by Monday, end of the 11:59 p.m. Monday, it needs to be in the MLS. That's because it's two business days, 48-hour rule, two business days. So if it's listed today, tomorrow's day one. We don't count weekends and holidays. Monday would be day two. So by 11:59 p.m. Monday would be when it has to be entered into the MLS. Same thing goes for status changes. When you have a contract, you've got the same 48-hour rule to make the change to the status in the MLS. And then there's a 24-hour rule for any public marketing. There's a 24-hour rule. This is the you may have heard people talk about clear cooperation, which is an NAR rule. And the NAR rule about clear cooperation is that basically we're not allowed to be taking a listing and not sharing it with the other brokerages once we start advertising it to the public. So as soon as you advertise publicly, which could be a sign in the yard, it needs to be in the MLS within 24 hours. I should put an asterisk on that 24-hour rule in the slide. The asterisk being that's only if you have a listing agreement signed and that agreement has started. In other words, I know that a lot of us might sign a listing agreement today, but the listing doesn't start until next week. You could put a sign in the yard today, and we're not putting it into the MLS until next week. That's not necessarily a violation of this clear cooperation rule because we don't have a listing agreement. By the way, you better trust your seller also, because if you have that sign in the yard and you don't have your listing agreement isn't starting until next week, they could sell the house and cut you out of that deal in the meantime, because even though it's a signed agreement, the date of the beginning of that exclusive right to sell is until next week. They don't owe you a commission this week if it sells. So if you're doing that, you're not breaking the 24-hour rule, but you are potentially losing a commission if they do sell this week and say, no, you're not getting paid because your listing doesn't start yet. There are MLS classes. If you guys have questions about any of this stuff, there's classes you can take. If you're a brand new agent, you probably just took that MLS class because they don't give you access to the MLS until you do take the class. There's also temporarily off the market status. So hopefully we all know about temporarily off the market. There's rules about temporarily off the market if you're not allowing showings for 2 consecutive days. You have to take it temporarily off the market. So what that means is my seller, the house flooded, and they're getting it cleaned up, and it's going to be on the market. We're going to be able to show it again in a couple days from now. Monday we'll start letting buyers come in again on Monday, let's say. Because it's more than 2 consecutive days of no showings, I have to move it to temporarily off the market. In the broker remarks, when you do a temporarily off the market, the MLS rule says you have to put a date of when it's back on the market. So in the broker remarks, I would just say back on market Monday, whatever the date is. But because it's more than 2 consecutive days, I have to move it to that status. That also means nobody's coming in or out of the house. So it can't be, oh, Danny's got a buyer from out of town in town only this weekend. And if they don't see it this weekend, then they're not going to see it. They're going to buy something else. Okay, Danny, I'm going to make an exception for you. Nope, that's a violation of the MLS rules. So when it's temporarily off the market, it's temporarily off the market. If there's a circumstance where I can get Danny's client in, then there's a circumstance that I can get anybody's client in, which means it's back on the market. And by the way, that back on market date that we put in the broker remarks, that's not set in stone. The basement flooded, we're getting it cleaned up. We think we're going to be back on the market Monday. I can put back on market Monday. Monday rolls around and there's still big machines and fans and dehumidifiers down there, and we still don't want showings. I can always go in and edit that back on market date. That's not a problem to change it if you need more time. The MLS has fees, of course. They're coming due pretty soon, so everybody brace yourself. We're going to have a fee of $228 due in March. We pay it twice a year, March and September. So and if you're a new agent, you probably just paid it a prorated version, a prorated amount. And then in March, you'll get the full bill for the 6 months, which would be $228. Supra access. Do we all know what the Supra e-keys are? Hopefully we do, but I wouldn't be surprised if most of us don't. We do have access to electronic lock boxes that you can buy through your board of realtors. Most of us are with ACAR, but if you're with Elgar, you can buy these Supra boxes from ACAR or Elgar. One of the nice benefits of MLS Now is that you get a free Supra key. In the old days, we used to have a physical electronic key that we would have to carry around, keep it charged. It was never, you wouldn't use it. It would drain the battery, and then you get to a showing and you can't use it because the battery's dead. It was a big pain, and that might be the reason why they're not very common in our area. But now with MLS, they've upgraded, and we get that key for free, and it's just on your iPhone or your Android. There's an app for it, and you can get access to it through MLS Now. If you're unsure about it, give them a call. They'll get you set up with it. It's, at least in our area, it's quite uncommon. I think if you go a little bit farther south into like maybe Stark County, you might start to see some of them. But up here in Cuyahoga and Summit, and Lake and Geauga, I don't think you're going to see many of those Supra keys. But if you ever do, that's how you get access to those lock boxes. When you're entering a listing into the MLS, you have to have at least one photo. You're allowed up to 35, and it's always better to have all 35 photo slots filled up if you can. But if there's some reason why you're not putting a lot of photos, you need to have a minimum of one. Anybody know what that one photo needs to be? Going once, going twice.
Is it
Oh, sorry, go ahead.
Is it the front of the house?
Front of the house, exterior front. At the very minimum, you have to have an exterior front photo of the house. Those photos cannot have any branding on them in the MLS. Can't have a sign in the yard. If your sign is already in the yard and you take that picture, they're going to kick that picture out of the MLS and give you I think they give a warning the first time around. But yeah, you can't have your name on it. You can't have your sign in that photo. No branding whatsoever. And then, of course, this is an important one now, especially now because of all the lawsuits that are flying around with realtors. We can never advertise our services as free service. We are not working for free, even if your buyer's not paying you. Well, first of all, our buyers all pay us a commission of $295. So it's not free because it's $295 to our clients. We waive that $295 if your buyer is FHA or VA, because those institutions don't allow that fee to get paid. So even if you're working with an FHA or VA buyer where we're waiving that $295, you're still not working for free because you are getting paid. It's just you're getting paid from the seller's proceeds. So we can never advertise as a free service. Everybody good up till now? Questions, comments?
Can we get a copy of these slides?
Yeah, absolutely. I can send it to Brian and he can share it with you guys.
Okay, I appreciate it.
Who asked me that? Sorry, I'll make sure that you get it.
Toy Porch.
Oh, Toy. Okay, thanks, Toy. Yeah, I'll make sure that it's sent out to you.
Okay.
Okay. Here is our Keller Williams living office info. You may be asked for our office license number. It's actually REC dot and then those numbers, but it's 2020-009051. I just keep that written up on my whiteboard in my office, as maybe save a note in your phone or something like that with it so that you have it when you need it. Actually, with this last MLS upgrade that we just got, it's easier because it's also listed in the MLS now. They added the license numbers into the MLS, not just the MLS IDs, which are different. If you ever need our EIN, it's our employee identification number. You probably, honestly, will never need this. You might have a referral to another agent where they're paying the brokerage a referral fee, and then another brokerage may ask you for this. But generally speaking, on a normal transaction, there's really no reason why you're going to need our EIN. And even on a referral, they're not going to ask you for the EIN. They'll ask you for the W-9, which is our tax form, which you can find that in .loop. It's under the KW Living files, the templates there. If you click on KW Living and search W-9, you'll find that form in there if you need it, and that EIN is listed on that form too. The MLS Now office ID for our office is 9181. Everybody always used to confuse the office ID with our office license number. Those are the office license number is with the state of Ohio. The MLS ID is just with MLS Now. So don't get those confused. A lot of times I see on the last page of our purchase agreement where it has all the licensing information. I notice a lot of people there. There's a question about, or there's a space there for our office license number. And I see a lot of people filling in the blank there with 9181. That is incorrect. That is not our license number. That's just the MLS ID. All right. There's something called a NAID ID, NAID number, which is used for selling HUD properties. If you ever have a HUD list, a buyer for a HUD property, you're going to need this number. You'll also probably want to reach out to me before because we have to, there's a new rule with HUD that we have to register each individual agent with HUD. It used to just be our office was registered. Now we need each individual agent to get registered. So if you're going to be submitting an offer on a HUD home, please call me first and we will get you added to the HUD home store, registered at the HUD home store so that you can do that. But you will need this NAID number as well to submit that offer. So if you want to jot that down, again, I keep it on my whiteboard in my office. So when I need it, it's in front of me. Keep it in your notes in your phone, wherever you need to keep it. There's a NERDS ID, which I think most people still call it the NERDS ID number. Although I think NAR changed the name to M1 a couple of years ago. But that is your NAR membership number. We each have our own individual unique number with NAR. If you're unsure what your number is, you can go to the NAR website, which I can never remember their website. I always type in NAR.com and it takes me to the National Association of Rocketry or something like that. It's not NAR.com. But if you find the NAR website, you could do a lookup of your M1 number or your NERDS ID number, and you can find it there. Okay, going to talk about commissions, and the first one, antitrust. I think this is a pretty big one. I see on all these Facebook groups lots of what I would consider violations of the antitrust law. There's the Sherman antitrust law. It's somewhat of a new law. It came out in 1890, so it's, you know, if you want to call it new, it's definitely not new. It's been around for a while, and we are not allowed to fix our commissions with other brokerages. This is a brokerage thing, not an agent thing. So you guys should never be talking about commissions with what you charge for your listing or asking another agent what they charge for their commission if they're not in our brokerage. Within our brokerage, we're allowed to have those conversations. And Keller Williams policy is that we leave it up to you. This is your business, right? So our policy with commissions is you can set your own commissions, whatever you feel is fair. Your commission cannot be less than 2%. The commission that you receive can never be less than 2%. I'm sorry, it has to be a minimum of average of 2%. It can't be less than 1% ever. As long as you have an average of 2%. So if you're averaging 3% and you're selling mom and dad's house and you say, Mom and Dad, I'll just charge you 1%, that's totally fine as long as that doesn't drop you below the 2% average in a year's time. But we're not allowed to have those conversations with anybody outside of our brokerage. By the way, those numbers I just gave you, the 2% and 1%, that is what you receive or Keller Williams Living is receiving. So if it's your listing, you can't, I'm not saying that you can list it for 2%. I'm saying the listing side of that commission can be 2%. Obviously, you'll have to add in whatever the co-broke is paying, is getting paid. So if you're taking a listing and you want to pay a co-broke 3% and you're only taking 2%, you need to put in the listing agreement that it's a 5% commission. The next line talks about co-broke. So this is what we're offering to the other agent. Again, it's up to you. You can offer whatever you want in the MLS. The MLS is our contract to cooperate with other brokers. So when it says the commission in the MLS says they're paying you 3% on the first 100, 2% on the balance, that's what you're getting paid. If you're looking at a discount broker's listing and they're only offering you 1%, or I've seen some of them at like $500 or $1,500 or whatever, a flat fee, that's what you're accepting from the seller. One way to make sure that you don't get such a low commission is by having a a buyer representation agreement, an exclusive right to represent a buyer, because those agreements within our brokerage say that you're the exclusive agent for that buyer. They can't use anybody else during a specified period. It's almost like a listing agreement, but with a buyer. And it also says that you won't work for less than fill in the blank percent. So if I say I won't work for less than 3% and I go show a listing that's offering me 3%, great. I'm not asking the buyer to pay me anything. But if I'm telling that buyer and they're agreeing that I'm getting paid at least 3%, and I go show a discount brokerage listing that's offering me 1, that means the buyer's got to pay the difference of 2, right? So that's one way to make sure that you aren't working for less than you're worth, I guess. Okay, so the MLS is your contract for the commission amount, which means that if they're offering you 1%, we're not allowed to go back to them and say, hey, I want to write an offer, but I want you to agree to pay me 3%. No, that's not okay. And it's also not okay if you're offering a commission for that on your listing. You know, if an agent ever calls you and says, hey, can you offer me more, or I don't think you're doing a 50-50 split, I want a 50-50 split on that commission, would you pay me more? The answer should always be no. The MLS is our contract for commission amounts, so that's what we're offering. In order to get paid a commission when you close on a sale, those commissions come into the brokerage and the brokerage pays you out per our independent contract agreement, which we all know we have a split. You're either on an 80-20 or a 70-30, whatever you chose, until you cap, and then you get 100%. But we will not pay you your commission unless we have all your required documents in command. So make sure I'm not going to go over all those required documents, but make sure you go through that checklist. There's a checklist for buyer sales and for listing sales. Make sure you go through the checklist, and if it's a required form, make sure it's there. And then, of course, we have the additional commission of $295 that all of our clients pay, whether it's a listing or a buyer. All our clients pay $295, with the exception of, like I said before, VA and FHA. Those institutions don't allow it to be paid. Divvy is on that list of exemptions for the $295. So if you're selling a home to Divvy, if you're listing a bank-owned property, or if you have a short sale listing, those don't allow those fees to get paid, so we waive it for that. Outside of that, there's really no waiver on the $295. All of our clients are going to pay that $295 fee. If you choose to waive it, that's fine. I have an investor who's a really good client of mine. He's bought lots of houses, and so I've made a business decision to waive it for him. And that's fine. I can waive it for him. But if you do that, you just need to understand that the office is not waiving it. So when I waive it, my client doesn't pay it. But when the office receives the commission check, they are taking that out from whatever is received, because that particular investor is not exempt from that $295. Questions? Okay. Hopefully we all know about showing time when you schedule a listing or schedule a showing. Hopefully most of our showings are being scheduled through showing time. All of our listings should be going through showing time, unless there's some reason why you don't want it to, but it's showing time. Membership fees are included in your office fees. We're paying it for you. You have it included in those monthly fees that you're already paying the office. When you take a listing, it should be going through showing time, and you're going to have to first you'll put in the MLS, and within, I don't know, an hour or so, that listing will get sent over to showing time. You'll need to go into showing time. You can call them or go online into the program and put in the instructions on what the showings are for your client. You get feedback through showing time. So if you're the buyer's agent showing something, I think it's courteous to give feedback to the listing agent after the showing, and that is usually a automated email from Showing Time. And as a listing agent, you probably want to automate that. So it's automatic where it just sends out an email to the agent who showed that listing. Um, and you can choose to have that only come to you, or you can have it sent to both you and your client. That's a personal choice, whatever works well for you and your business. I can tell you, I like to just have it sent only to me, because agents sometimes aren't so friendly. So if they write something, maybe they're brutally honest and it's offensive to your client, maybe you want to screen that before you share it. So that's why I choose to do it that way, but that's personal preference. If you want it automatically to get sent to your client when an agent provides the feedback, that's up to you. You can also block out showing times if your seller's not allowing showings. So, I work from home, I'm there from 9 to 5. You can show it after 5, you can show it before 9, but 9 to 5, Monday through Friday. That's maybe an extreme example. Maybe they don't really want to sell their house if they're not allowing showings that often, but you can do a showing block. You can also do a showing block for days. So no showings today because my my friend's in from out of town and spending the weekend with us. So no showings for today and tomorrow. You can always block out particular days. Just again, remember if it's more than 2 days of no showings, that you have to put it temporarily off the market in the MLS too. Showing reports, showing time is great with showing reports. So when I want to know how many showings did I have on my listing, I can go back through a particular time frame. You set your time range, and it tells you how many showings, who the agents were, if they provided any feedback. It'll all show that on the report. It's a really useful tool, especially for, well, we are getting back into it now. For a couple of years, we never really took price reductions because the market was so hot. But it's a useful tool if you have a house that's sitting on the market not selling, to pull out that report from showing time to help you get a price reduction. The other thing, the probably the biggest thing that showing time does is schedule your appointments for you. So I have a listing, you want to schedule it, you're going to reach out to showing time to schedule it. Showing time's going to know it's either a go and show, that's a courtesy call, or an appointment required. Those are the 3 choices you have on how to set it up. Go and show, great for vacant houses. The seller doesn't care. You want to go tomorrow. It gets approved right away. As soon as that agent puts in the request, it automatically gets approved. Courtesy call, it's not listed on this this page here, but a courtesy call is you can go, my client doesn't care that you're going tomorrow at 1 o'clock, but they just want to know that you're going. So showing time will approve that showing, and then they'll reach out to your seller and say, by the way, Rick's going to be there tomorrow between 1 and 2. And then an appointment required is good for occupied homes. And that's, I'm going to call in and say, I want to show this house tomorrow between 1 and 2. They're going to say, great, we will confirm it and get back to you. Then they're going to contact your seller and say, Rick wants to go tomorrow between 1 and 2. They approve it. They call me back and say, here's how you get it. So questions about showing time? Okay. So now let's talk about purchase agreements. Who can sign a purchase agreement? So if you're or any contract, a listing or a purchase, sorry. If your client is a single person, then they're the only ones that need to sign it. If they're married, it's possible you need both signatures. It depends on the transaction. So in the state of Ohio, it takes one person to buy and it takes both spouses to sell. So I can buy a house today without asking my wife's permission. But if I want to go sell that house, even though she didn't purchase it together with me, I'm not allowed to sell it without her signature on it. And that's called dower rights. That's the last line on here. Dower rights were one of the last states to have dower rights. So it basically takes one spouse to buy and both to sell. Now, if your client is married and buying it on their own and taking a mortgage, you're gonna want to have their spouse's input in everything because they will have to sign off on their dower rights um, as part of the mortgage documents. So you do want to be mindful of that too, that if there's a mortgage involved, that you probably want both spouses on board. Trust is your client, is your buyer or seller a trustee? Are they is it an estate? Is it an executor of the estate? Um, that's fine. They can, and I guess same thing goes for a POA, a power of attorney. Um, that's fine. They can sign as a trustee or an executor or a power of attorney. You just are going to need to see those documents. We'll need to verify that they are really the trustee. Um, you know, there's different types. There's different ways you can set up a trust. You can be a trustee. You can be a successor trustee. You can be a co-trustee. So you need to make sure that you've seen those documents and you know that you're getting the right person to sign on behalf of that trust. Because if somebody, you know, maybe they're not trying to be deceitful, but maybe they're a co-trustee and they tell you, yeah, I'm the trustee, I can sign for everything. And then you get to closing and you find out they're a co-trustee. Without both signatures, it's not done properly and you're going to run into problems. So just verify those documents if you run into that situation. Also with power of attorney, I would say it's really important to verify those documents because not every power of attorney gives you the right to sell real estate. So you need to have a copy of that power of attorney. I usually walk it over to the title company and say, hey, will you guys accept this power of attorney to buy or sell a property? And they'll let you know if it's the right type of POA for you to do that. And then we've got divorces. I love divorces because you get hopefully 3 deals out of it. You sell, hopefully you sell their house, and then hopefully you've got a good relationship with both spouses, so you help each of them buy a new one. So you can end up with 3 deals. But of course, divorces can be very tricky. Trying to get both spouses to agree with each other on selling. So you just need to be mindful. And then also, if they're going through a divorce and they're buying with you, you need to make sure that they're aware about dower rights. If they're still married, the divorce is not finalized, their future ex-spouse has dower rights when they buy something. It's now going to be a marital asset. So when their 2 attorneys start fighting over all the assets and who gets what, now that I bought a house, it's a marital asset and my wife can try to take part of that from me. It's not impossible to buy a house while you're in the middle of a divorce. You just want your client to consult with an attorney first because they can draft up some paperwork to make sure that it's excluded from any divorce proceedings. So just be mindful of that. Any questions up until now?
I have a question.
Yeah.
Where do you, I feel like dower has always confused me, even when I was going through the training on Hondros. Do you
Mhm.
have a great source that I can like read into about that? Because I feel like it's not catching, and I'm sure it's not a huge thing that we come across often, but like even the situation that you explained, if he goes and or she goes and purchases a home and they're still married, to have them speak to a lawyer, but wouldn't that spouse still have dower no matter what? I don't know. So that's why I'm like,
No,
well, where do you learn
no,
this
that's
stuff
why
at?
you bring in the attorney to make sure that they don't
Okay.
have dower rights. And I've
Okay.
done that before. Couples in the middle of a divorce and it's not final, and she was keeping the house and he was still living in the house because he needed somewhere to live, and they both wanted him out. So he went and bought a house before the divorce was final. I just made sure that he
Mm,
spoke with his attorney beforehand. They drafted some sort of document, which honestly I never saw, and it wasn't really my
mhm,
business to see. I just
mhm.
knew that it happened behind the scenes. So she probably waived her dower rights, or somehow they structured that purchase that it was not a marital asset. So
Okay, so the best recommendation is to always refer to an attorney to work that out versus going any further with the transaction.
yeah, I would just say, look,
Okay.
if you buy this house now, your future ex-spouse is gonna have rights to this property, and it will become a marital asset. And when you guys are fighting in court about who gets what, uh, this house is up for grabs. So you just want to talk to your attorney and make sure that you structure this purchase correctly. It might be that the future ex-spouse signs something saying that this will belong to the other spouse, and we won't fight over this. Um, and it may be that it's being purchased in a trust. I'm not sure if how that should, I would think, I'm not an attorney, but I would think that if you
Mhm,
buy it in a trust, if as long as you're the sole trustee, that would probably exclude it from the marital assets.
mhm.
But yeah, I, I just tell people consult with your attorney before you move forward with that purchase if you're still married in the process of a divorce. Otherwise, we're going to be fighting over it, or they're
Gotcha.
going to
So
be fighting
in
over
other
it.
words, if in other words, if they don't want to, like, let's say they're just over it and don't want to consult with an attorney, then we would need to then pull in the current wife to sign off dower no matter what, even if they're going through a divorce.
Well, we're not going to do that because that's the job of an attorney.
Gotcha, gotcha.
Yeah,
Okay, all
yeah,
right. Thank you.
yep. Other questions about this page here? Okay. Escrow letters. So to get paid, we need to fill out an escrow letter. The title companies are going to want us to fill out these escrow letters. It's in dot loop. I think it's fairly self-explanatory. Sometimes some of our agents do have questions about it, so you can feel free to um, ask me about it. If you're in productivity coaching, you can ask Janice about it. Um, and but yeah, the escrow letters basically, here's the general idea of where everything is. Buyer's name, the seller's name, their contact information. This is going to the title company, so they need to know how to contact them. What are you getting paid on this? Was there a home warranty? Who's paying for that home warranty? It could be the buyer, it could be the seller, it could be the agent. Are there any closing cost credits that are being provided through the transaction? Inspection invoices doesn't typically come up, but if there's someone that said, okay, I'll wait to get paid at closing, then you can add that in there. Your co-broke information, so whoever the other agent is, all their contact information. What's the closing date? Who's the lender? That all goes on the escrow letter, and it's a fill in the blank form if you haven't seen it yet. So it should be fairly easy to put together. Um, and the title company is going to compare yours to the other agents and make sure they match. They usually do. Every once in a while, there's a discrepancy, and then the title company will reach out and say, "Hey, what's going on? You said the buyer's paying the home warranty, and they said the seller's paying it. Who's paying the home warranty?" Choosing title company. So that's always negotiable between buyer and seller. Um, RESPA says that the title company choice is actually the buyer's choice. But let's be honest, most buyers and sellers have no idea who a title company is, what they do. They don't know anybody in the title business 9 times out of 10, right? So who ends up fighting is the buyer's agent, the seller's agent usually end up being the ones to fight over it. But it's negotiable, and because it's a term of the contract. Um, if you're using American Title Solutions, we have an ABA, affiliated business disclosure. So that needs to be included if you're using American Title Solutions. Some of our agents have their own ABAs with different title companies, and if you do, that's fine. Just make sure that you have your own ABA included in all your paperwork. But the brokerage is affiliated with American Title, so even if you personally don't have shares at American Title Solutions, it's still going to be a required form, ABA. if the seller's paying the cost, I know I just said that the buyer gets to choose it, but if the seller's paying some closing costs, I would say that the seller gets to choose it. And the last thing about a title company I would say is I never lose a deal over a title company. I mean, that would be the silliest thing to lose a deal over. All the other terms in the deal are good, except for I chose American Title Solutions and you want Infinity Title. We're not going to lose a deal over that last item. That would just be silly. Questions about title company? Home warranties. So we use America's Preferred Home Warranty here in our office. You have to it's a required form. There's the order form. That's a required document. Every client needs to have that signed. If they're accepting it, there's two places that our clients can sign that form. If they're accepting the warranty, they can sign on it that they're accepting it. And if they're choosing not to have one, there's at the bottom of the form, there's a waiver. It is a required form. The reason being is that they do help us. They do help in the protection, in our defense if there's a lawsuit regarding a particular transaction. And that's what they'll only pay that defense for us if we have that either accepted or waived. If you're taking a warranty, you have to have it registered with America's Preferred Home Warranty. I think it's realpro.com or realpro.net or something like that. You just have to go online, and Renee Kozak does lots of classes, I think once a month, in the office on Zoom for our office, to show you how to do that. And then there's the data collection sheet, which is really just making sure you register it. They do ask some questions, I think, about the appliances brand names. So you'll want to take notes on the brand of furnace, air condition, stove, refrigerator, I think maybe water tank also. So make sure you get notes on that, because if you do fill out if your client accepts a warranty and you're the agent that sold it, and you've registered it and you've filled out all the information that they need, they do pay us $100. That comes to Keller Williams Living, and we split that 50-50 with our agents. So every warranty that you're responsible for selling, you're getting a bonus of $50. So if you want that $50, if you're doing big business, those $50 checks add up pretty quick. So I like to have those. And the last point says, make sure you have either the accepted contract or the waiver for it, which I already talked about. Questions on the warranty? I really like the warranties, by the way. I think they're a great tool. First of all, if you have a listing that's maybe got an older furnace that's working, an older water tank, but it works, but maybe it's past its life expectancy, it's a good selling point. We can say, hey, we're not putting in a brand new furnace because the current one works, but we're giving you a warranty. So if it does break in the next 12 months, you get a repair or replace it with the deductible. So I think it's a good tool to have. I personally have one on my house, and I keep on renewing it because it's nice. Consumer guide. We need to have all of our clients sign the consumer guide. I probably beat this to death with you guys already. You've heard me say in lots of meetings and different places about getting our consumer guide signed. It's important that you have it signed at the first time you meet. Before you talk about anything confidential, before you talk about their finances or their personal situation, they need to understand agency relationship, and that if you're not representing them, excuse me, that they need to understand that you have a duty of confidentiality to your clients. So if they're unrepresented, you don't have that duty of that fiduciary responsibility for them. So that's why it's important. The one exception to handing that out at our first meeting would be open houses. If you meet them at an open house, it's not a requirement. But if you meet them at an open house and you say, hey, let's meet up at Starbucks and we'll do a buyer intake interview so we can start working together, you better give it to them at that first meeting after that open house. All right. Talking on the phone, talking about finances, I would like to see our agents sending that out before you get into personal conversations on a phone call. So I've sold quite a few for sale by owners in the last couple of years. When I reach out to them and they agree to allow me and to show their house to one of my clients, before I step through that door, while I'm on the phone with them and they say, sure, yeah, bring your client by. Great. Before I come in, I need to, the state requires I have a couple signatures from you. One of them, the one that the state requires is going to be that consumer guide to agency relationship. By the way, it's not really necessary for the slide, but it goes with my example, is that if it's a for sale by owner, we do have an unrepresented seller agreement. And I also have them sign, I send them on .loop the consumer guide and the unrepresented agreement via .loop before I step foot in the house. Now I've disclosed to them how agency works, and the unrepresented seller agreement tells them, hey, I don't represent you. I will treat you honestly and fairly, but don't tell me confidential things. Don't tell me that we're asking 300, but I would accept 275. Because I'm going to go tell my buyer who I do represent, and I do have a fiduciary responsibility. So now they're on notice of how that all works. So I always send that out on .loop before I even step foot in the house. We sign these consumer guides per client, not per property. So you don't have to, if you're showing them several properties, or if they're listing 2 houses with you or buying one and selling one, you only need one consumer guide. That's sufficient with the state. Now, if you ever get audited by the Division of Real Estate and they look into a file and they see that that consumer guide was signed the same time as your purchase agreement was signed, you're going to have a problem. So please make sure that you're having those signed timely. Any questions here? Okay. Showing houses. So when we're showing houses, this is just, I guess, basic courtesy of agents and some rules for us agents as well. So showing remarks, I just tell people, make sure you look at the showing remarks. There's several places that agents put it in, so you want to check all those places before you go show the house. Number one is it may say something in the broker remarks, so make sure you're checking broker remarks if they say anything specific in there. Also through showing time or whatever, however you scheduled the appointment, if they give you other instructions, make sure you pay attention to those remarks. Things like dogs in the house, there's cameras in the house, take off your shoes, those kind of things is what we need to be mindful of. We're going into somebody else's home, so just be courteous. Being on time, again, that's just going back to what I just said, being courteous, to be on time. If you're running behind, I usually schedule my appointments for like an hour time frame. If I'm showing 2 or 3 or 4 houses at a time, I'll usually overlap those hour showing time frames. If a house allows me to, towards the end of my tour, I might make it an hour and a half or 2-hour time frame if that particular listing allows for that. So just make sure that you're there during your time frame. Never leave the lockbox open. So make sure that you take the key out. You don't leave the code showing on the lockbox when you go inside the house. Take the key with you or put it back in the box. But if you put it back in the box, make sure you scramble it. Never leave that box open, and never give that code to anybody. That you will get a license suspension if you ever give that lockbox code to anybody. Never leave the door open for another agent. If I'm showing the house and I got there first and you come in after me, I think the best practice would be for when I come in, I'm gonna put the key back in the lockbox, and then when you show up, you're gonna have to go in the lockbox. I'll be in the house, but you should be going into the lockbox to get the key. Sometimes, I'm walking out, somebody else is walking in. I'm just gonna make sure I know who that person is. That I'm not giving the key to some random person. I better know. I gotta know who you are, or you gotta show me your business card for me to hand you that key out of my hand. So just be mindful, because that's a good way to get your license suspended. Leaving a card, that's just there's a couple reasons. I think number one reason is just common courtesy, so the seller knows that you were there. That's one reason to leave a card. Another reason to leave a card is if that house doesn't sell, that seller's got your business card. They know how to find you, and hopefully they'll reach out to you and say, hey, I know you showed my house a couple times and it didn't sell with that agent. Would you be interested in listing the house? So that's maybe another reason to leave the card, but I think the primary reason is just so the seller knows we were there. Turn off the lights or not. Again, that goes back to the first point here, the showing remarks. Sometimes you're gonna see in there that please turn off all the lights. Sometimes it'll say leave the lights on for showings after you. The seller might have left a note saying please leave the lights on. So just make sure you're following those instructions. Make sure that if you open the door, it's locked when you're leaving. If it was already open, then don't lock it. And just make sure that you're leaving the house as you found it. And then the last thing, again, being redundant, but just scramble that code up if it's a combination box. And then questions. Sorry, I'll pause for a second if anybody's got questions. Okay. Again, I don't see the chat box, so if there's anything in there, just unmute and let me know. Feedback after a showing. I just think it's common courtesy. Say, yeah, my client, it's not the right property for them. The rooms were smaller than they need, or the space just doesn't work for them, or they felt it's priced too high, or the carpet's in really bad shape and they don't want to deal with that. Whatever the feedback is, why they do like it or don't like it, please provide feedback. You can do that through showing time, which is the most common way. You can call the agent, you can text the agent. I personally like it in showing time. It's easier for me to provide feedback through showing time because then I don't have to talk to anybody. I can do it at 11 o'clock at night when I'm sitting on the couch, or and I like to send it that way. I like to receive it that way. Working with agents, I think the bottom line of this slide is just so that we're working together. Obviously, I represent my client's best interest and you're representing your client's best interest, but hopefully we all want the same end result, which is the buyer wants to buy it, the seller wants to sell it. We just need to come to terms. We're not adversaries here. And we're going to be doing other deals together with our co-brokes in the future. So we just want to be courteous to everybody and keep a good working relationship with our fellow agents and communicate well, and make sure that it's not about winning or losing. It's about doing what's right for your client, and hopefully the two sides can agree what's best for the seller and what's best for the buyer. We end up getting the thing closed. Earnest money deposits. So earnest money is never cash. It's never a cash payment. They're not going to accept cash. Back up for a second. Who accepts earnest money? Keller Williams. It's allowed to be held by the broker. It's allowed to be held by a title company. Could even be held by the seller if that's what is negotiated. But and there's no requirement to have earnest money. However, it's certainly customary to have it. And Keller Williams will not hold earnest money for our clients. So do not have them send it to Keller Williams. We will not accept it. It's too much of a liability. I recommend having the title company hold it. Title company will not accept cash. They will accept personal checks and cashier's checks. The best way that I think is wiring the earnest money, or most title companies have some sort of ACH option online. I think most title companies that we all work with, you can go to their website, click the link to deposit earnest money, you put in your banking information, and it just takes that money out of their bank account and deposits it. And you get a receipt right there online. That's probably the easiest way. We're going to make sure that it's being held by the title company. We really shouldn't even be touching this earnest money. If they're sending in a personal check, my client doesn't want to do a wire transfer or an ACH online, and they really prefer to do a personal check and mail it in, I'm going to tell them to send me a picture of it and then drop it in the mail to the title company. I don't want to hold it. I don't want it to get lost while it's in my hands, or I'm the one who mailed it and the mail got lost. And now I'm somehow responsible for that earnest money check. So that's why I would say have them send you a picture of it and they can mail it themselves. And by the way, if you're getting a copy of that check, typically what I would do is if my client is sending a check to the title company, they're going to send me a picture of that check. I'm going to share a picture of that check with the listing agent. But I would ask that you guys are mindful about account numbers being on those checks. So I usually ask my clients when they send me that picture of the check, just cover up the account number on there so that it's not getting into the wrong hands. You can do that on your iPhone with, you can edit and mark up and just scribble over it so you block it out. Take a pen and put it on top of it. For that photo, whatever, just make sure that it's blocked out. And if your client doesn't block it out for you before you send it on to the other agent, I would definitely make sure that you're blocking it out. Earnest money, what happens if the deal falls apart? A typical deal, unless you're doing something out of the ordinary, but typically our deals have two contingencies for the buyers. That's your inspection contingency and your finance contingency. Your earnest money gets deposited with the title company. It gets credited towards the purchase price of the house. If the deal doesn't close because of your inspections, then your client's earnest money is protected and they should get it back. Same thing with financing. Typically, our clients have finance contingencies, and if something happens where they can't get financing, they should get the earnest money back. And the reason I keep on saying should is because the title company is only going to give that money back to the client once there's a mutual release signed. So even though the client has the right to back out, we still need a mutual release, or that earnest money is going to sit in the escrow account. There's only a few ways that money will ever leave the escrow account. Number one is what we hope for. It's that the deal closes and it gets applied towards the purchase. Number two would be a mutual release. We've agreed, we had some material defects on the inspections. We couldn't agree who's going to repair it or credit for it or whatever the case may be. So we terminated, we all agreed on the earnest money. Option three to get earnest money back would be a court order. So we didn't close, we didn't get a mutual release, buyer and seller are fighting over this, so we went to court and the court made a decision about who gets this earnest money. And then the last way the earnest money is returned is after 2 years of holding that earnest. So the deal didn't close, we don't have a mutual release, and we never went to court to fight over it. So we've gotten to 2 years later, and now the title company is allowed to return it to the person who made the deposit. those are the only ways that earnest money leaves the account. Any questions about earnest money deposits? Seller net sheets. This is really important, guys. Sellers have a number in their mind of what they want to sell the house for, but they don't always understand what that means that they're going to actually have in their pocket after the sale, because there is closing costs, there is commissions. In Ohio, we pay taxes a year behind, so there's going to be taxes that come out. So there's cost of sale items like closing costs and commissions. There's taxes which are going to affect their net proceeds. It's not really a cost of sale, because if they don't sell their house, they still have to pay those property taxes. It's important to sellers because it's going to tell them how much they're going to have at the end of the transaction after all those credits are said and done. So taxes are an important thing for our sellers to understand, as it affects their bottom line. If it's a tenant occupied house, it'll have credits for prorations for the security deposits and the rent. If it's in a condo or homeowners association, it'll have credits and prorations for those fees. So the seller net sheet is good because, I have a seller right now who's telling me that they want to sell for 300,000. And when I started asking them about that number, it really comes down to what's their net they have in their mind of what they need to go home with. And so now that I understand that, I can run a net sheet and say, look, you want a net 260, you can actually sell for 290 and still net what you need to net. So it just helps with those conversations. You can get those net sheets from the title company. If you call our partner title company, American Title Solutions, I believe they have a website that they can set you up where you can put in all the information yourself, and then it gives you the net sheet, which you can print out and show to your client. Most title companies have that. So if you're not using American Title, if you're using a different title company, you can always get those sheets from them as well. Or you can just call them and tell them the details of the transaction. They can run it for you. That's the end of my presentation. Do I have any other questions? Nobody? All right. If there's nothing else, I think you guys, I just realized my camera's been off this whole time, guys. I'm sorry. If there's no other questions, then thank you for coming. And if you guys think of anything, then please reach out to me.
Thank you.
Thanks, everybody. Thank you.
Bye.